Polity and governance. Rule of law. Rule of law means absolute supremacy of predominance of regular law as opposed to influence of arbitrary power, and excludes existence of arbitrariness or even of wide discretionary authority on part of government. Procedural aspects. Independent and impartial courts to settle disputes. Right to representation by counsel. Supremacy of law. Nobody can be punished else for breach of law. However, in a constitutional democracy, the laws enacted should just fair and reasonable. In India, doctrine of basic structure ensures that the judiciary can overturn enacted legislation, including constitutional amendments, if they are not just fair and reasonable. A.V. Dicey's theory of rule of law. Law is supreme or supremacy of the law, equality before the law, predominance of legal spirit. Liberty or freedom. Freedom as the absence of external constraints, and freedom as the expansion of opportunities to express oneself. Two concepts of liberty: positive liberty, negative liberty. Positive liberty, it is concerned with looking at the conditions and nature of the relationship between the individual and society, and of improving these conditions such that there are fewer constraints to the development of the individual personality. The individual, to develop his or her capability, must get the benefit of enabling positive conditions in material, political and social domains. Negative liberty seeks to define and defend an area in which the individual would be inviolable, in which he or she could do, be or become whatever he or she wished to be or become. This is an area in which no external authority can interfere. Positive liberty, it is concerned with looking at the conditions and nature of the relationship between the individual and society, and of improving these conditions such that there are fewer constraints to the development of the individual personality. The individual, to develop his or her capability, must get the benefit of enabling positive conditions in material, political and social domains. Citizenship, some basics. Part 2 of Indian Constitution, from Article 5 to 11, deals with the citizenship and provides three modes of acquiring Indian citizenship. Number 1, by domicile. Number 2, cases of migration. Number 3, process of registration. Domicile. Article 5 mentions that the commencement of this constitution, every person shall be a citizen of India who has his domicile in the territory of India, and who was born in the territory of India, or either of whose parents was born in the territory of India, or who has been ordinarily resident in the territory of India for not less than 5 years immediately preceding the commencement of the constitution. Migration. Article 6 mentions about rights of citizenship of certain persons who have migrated to India from Pakistan. A person who has migrated to India from the territory now included in Pakistan shall be deemed to be a citizen of India at the commencement of this constitution, if he or either of his parents or any of his grandparents was born in India as defined in the Government of India Act 1935. If such a person has migrated from Pakistan before 19th July 1948, he has been ordinarily resident in the territory of India since the date of his migration, or for persons migrated on or after 19th July 1948, he must be registered as citizens of India. However, no person shall be registered as Indian citizen unless he has been resident in the territory of India for at least 6 months immediately preceding the date of his application. citizenship by registration, migrants and persons of Indian origin residing outside India. Article 7 allows citizenship by registration to such migrants who had after 1st March 1947 during partition migrated to Pakistan but returned to India under a permit for resettlement or permanent return issued by or under authority of any law. Registration. Article 8 provides for acquiring Indian citizenship by registration for persons of Indian origin residing outside. Such persons of Indian origin can register themselves with the diplomatic or consular representative of India in the country where he is for the time being residing. Dual or multiple citizenship prohibited. According to Article 9, no person shall be a citizen of India by virtue of Article 5, Article 6 or Article 8 if he has voluntarily acquired the citizenship of any foreign state. Rights of citizenship can be regulated by law made by Parliament. Article 10. Every citizen of India by virtue of this constitution shall continue to be Indian citizen subject to the provisions of any law that may be made by Parliament. Article 11. Parliament has power to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. Criminal justice system. Niti Aayog in its 3-year action agenda highlighted that there were the 3 areas in which criminal justice system needs reform: statutory and administrative laws, the judicial system and police. Even Malimath committee has suggested certain recommendations towards reforming India's criminal justice system. In India, laws pertaining to criminal justice system branches out from the 3 fundamental provisions of the Indian Constitution, namely Article 20, 21 and 22. Article 20 provides for a double jeopardy and the right against self-incrimination. Article 21 ensures personal liberty unless prosecution is justified through procedure established by law, whereas Article 22 protects against arbitrary arrest and detention and ensure that a person arrested must be produced before the magistrate within 24 hours and has the right to be represented by the lawyer of their choice. Article 20 protection in respect of conviction for offences. No person shall be convicted of any offence except for violation of law in force at the time of the commission of the act charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offence. No person shall be prosecuted and punished for the same offence more than once. No person accused of any offence shall be compelled to be a witness against himself. Article 21. Protection of life and personal liberty. No person shall be deprived of his life and or personal liberty except according to procedure established by law. Article 22. Protection against arrest and detention in certain cases. No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of a magistrate. Nothing in clauses 1 and 2 shall apply to any person who for the time being is an enemy alien, or to any person who is arrested or detained under any law providing for preventive detention. So in this section, let us through important terms associated with criminal justice system which affects the rights of citizens as guaranteed under the Indian Constitution and other laws of country. Understanding FIR and zero FIR. First information report FIR is a written document prepared by the police when they receive information about the commission of any cognizable offence. It is the first step towards registering of an offence, which further leads to investigation by the police. Informations about any cognizable offence is written down by the police as FIR under section 154 of Criminal Procedure Code. The term FIR, however, is not mentioned either in the Indian Penal Code or Criminal Procedure Code. Cognizable offence. Cognizable offence has been defined under Code of Criminal Procedure (CRPC). Cognizable offence means in a case which a police officer may arrest without warrant. Cognizable offences are usually offences which are serious in nature, like murder, rape, dowry, death, etc. Dowry, death, kidnapping, etc. Non-bailable offence. Non-bailable offence has also been defined under CRPC. When a person is accused of non-bailable offence, then in such case bail can only be granted by the court and not by an officer. Application for bail must be made in court in such case of a non-bailable offence. Zero FIR. Outside jurisdiction. Registering FIR by police about a cognizable offence which has not happened within the jurisdiction of the police station concerned. Such police station registers an FIR and then transfers it to the concerned police station under whose jurisdiction the offence has occurred. For further investigation, this is called a zero FIR. Since the FIR is registered outside the jurisdiction of assigned police station, no serial number is assigned to it, and instead it is assigned a number 0. Such FIR registered irrespective of the area where the offence has been committed. What if the police refuse to register an FIR? If a magistrate refuses just to register FIR under section 154 of CRPC, then the information can be sent in writing to Superintendent of Police SP of the district. If the SP is satisfied that such information discloses the commission of a cognizable offence, then the SP shall either investigate the case himself or direct an investigation to be made by an officer subordinate to him in the manner provided by this code, and such officer shall have all the powers of an officer in charge of the police station in relation to that office. If no FIR is registered, the aggrieved persons can file a complaint under section 153 clause 3 CRPC before a concerned court, which, if satisfied that a cognizable offence is made out from the complaint, will direct the police to register an FIR and investigate. What happens after an FIR is filed? The police will investigate the case and will collect evidence in the form of statements of witnesses or either other scientific materials. They can arrest the alleged persons as per law. If there is sufficient evidence to corroborate the allegations of the complaint, then a charge sheet will be filed, or else a final report mentioning that no evidence was found will be filed in court. If it is found that no offence has been committed, a cancellation report will be filed. If no trace of the accused persons is found, an untraced report will be filed. Parole and furlough. Bombay High Court has directed the Superintendent of Amaravati Central Prison to pay the legal expenses or the cost of a petition for denying furlough to a 60-year-old blast convict on stereotypes reasons. Parole. While parole is granted for the prisoner to meet a specific exigency or specific purpose, parole can be granted in case of short-term imprisonment. Duration of parole extends to 1 month. In case of parole, reasons are to be indicated before release. For parole, specific reason is required, whereas furlough is meant for breaking the monotony of imprisonment. When a prisoner is on parole, his period of release does not count towards the total period of sentence. Parole can be granted a number of times. Furlough is granted in case of long-term imprisonment. Furlough extends to 14 days maximum. It is not necessary to state the reasons while releasing the prisoner on furlough. The grant of furlough is to break the monotony of imprisonment and to enable the convict to maintain continuity with family life and integration with the society. Although furlough can be claimed without a reason, the prisoner does not have an absolute legal right to claim furlough. When a convict is on furlough, he is eligible to have the period of release counted towards the total period of his sentence undergone by him. The grant of furlough must be balanced against the public interest and can be refused to certain categories of prisoners. Since furlough is not granted for any particular reason, it can be denied in the interest of the society. There is limitation in the case of furlough. Types of prison. President Murmu, while delivering the valedictory address at the Constitution Day celebrations, highlighted about the situations of Indian prisons. What is a prison? Prisons Act 1894 defines prison as: prison means any jail or place used permanently or temporarily under the general or special orders of a state government for the detention of prisoners, and include all lands and buildings appurtenant thereto, but does not include any place for the confinement of prisoners who are exclusively in the custody of the police, any place specially appointed by the state government, any place which has been declared by the state government by general or special order to be a subsidiary jail. Prisons exist at 3 levels: taluk level sub jail, district level district jail, zonal or range level central jail. Issues related to 5th and 6th schedule. Demand for 6th schedule. MP from Ladakh has demanded inclusion of Ladakh in the 6th schedule for constituting autonomous district council, which is elected for a period of 5 years. UT of Ladakh has 2 hill councils in Leh and Kargil, but neither is under the 6th schedule. 6th schedule. Schedule 6 of the Indian Constitution provides for the scheduled and tribal areas. Article 244 clause 2 under Part 10 provisions of 6th schedule shall apply to administration of tribal areas in states of Assam, Meghalaya, Tripura, Mizoram, AM/TM. Autonomous districts. Tribal areas in the states of Assam, Meghalaya, Tripura and Mizoram shall be declared as autonomous districts. Autonomous regions. If there are different scheduled tribes in an autonomous district, the governor may, by public notification, divide the area or areas inhabited by them into autonomous region. District council. There shall be a district council for each autonomous district consisting of not more than 30 members, of whom not more than 4 persons shall be nominated by the governor, and the rest shall be elected based on adult suffrage. Regional council. A separate regional council for each area constituted as an autonomous region. Restricted power of district council. In an autonomous district with regional councils, district council shall have only such powers with respect to areas under authority of regional council as may be delegated to it by regional council in addition to powers conferred on it by this schedule. Legislative powers of district council or regional council. Make laws related to land or forest other than any land which is a reserved forest. Use of any canal or water course for agriculture. Regulation of shifting cultivation. Establishment of village or town committees or councils and their powers and any other matters such as town, police, public health, primary schools. Inheritance of property of marriage and divorce according to social customs.